Okay, folks, so I'm here to tell you about a change in the civil procedure rules that will affect everybody, lawyers especially, but also is of relevance to litigants in person. And that's the fixed cost recovery regime that's been introduced effective from 1st of October for cases where they're not a personal injury case. They'll apply from the date of issue of the case. So if you've already issued proceedings, you don't need to worry about this. Personal injury cases, they'll apply from the date of the accident. And it's quite a substantial kind of a sea change, although there's been a general direction, general move in this direction anyway over the past few decades. And that is basically capping legal costs, capping lawyers' costs, such that you just simply can't get more than a figure that's prescribed by tables in these new civil procedure rules. For certain stages of the litigation cycle, like, you know, you can only get X amount of, you can only get £5,000 if you settle pre-issue, you can only get £10,000 if you settle at the time of defence. You go all the way to trial, you'll only get £25,000. They're just arbitrary figures, but that's that's the change, yeah, limiting right from the outset the amount of cost you're ever going to get if you win your case. Even though it's been reasonable and necessary for you to do more work on the case, you're capped at a certain level. Now, what is that level? How is that level decided upon? Now, as a litigant in person, you still need to know about these rules because, you know, when you're filling in a directions questionnaire, for example, particularly at that phase, you're going to need to know about these rules. But you're also going to need to know about these rules if you're a smart litigant in person running your own case, because there are certain tactical advantages for litigants in person as a result of the changes in these new rules. So what are these new rules? Basically, the Civil Procedure Rules Committee, it's not like a change in the statute, it's given powers to this committee to make changes to those lovable civil procedure rules by the creation of a new intermediate track, and, as I say, by the introduction of these fixed costs, which will apply not for small claims. Don't need to worry about it if it's a small claim. They will apply in respect of fast track, and they will apply in respect of the simpler carve out of a simpler section of a multi-track case, which is called intermediate track. So in a way, you've got kind of a less simple multi-track claim and a more complicated multi-track claim, and it's intermediate. It's called, at the simpler end of the multi-track, it's called the intermediate track. If a case is 3 days or less, if it's less 3 parties or less, if there's no more than 2 experts per party, then it's probably going to go into this new intermediate track if it doesn't belong in the fast track. Typically, fast track claims £10,000 to £25,000, although don't forget it's not just about the value. There are other factors that come to play, particularly, most importantly, the trial length. So if it's longer than 1 day, it might go into a higher track, even though the value is under £25,000. So that's, in a broad sweep of these changes. And just to reiterate, although there are some miscellaneous changes that you probably don't need to worry about, for example, Part 36, you probably won't, as a litigant in person, I wouldn't advise you try and make a Part 36 offer, or if you do, get a lawyer to help you to draft it because they're very technical. But in terms of 1 or 2 other changes, one critical one that important one that I'll come on to towards the end of the vlog, the main change is this capping on costs. Now, you've always needed to think about track allocation, and this is the area that these new changes are going to hit hardest. Before you issue proceedings, is it going into the small claims track? Because if it is, and you're up against a well-heeled opponent, well, they're not going to get their legal bill paid even if they win. So there are good commercial reasons for choosing a small claims track, because you won't have the danger of costs if you lose, and you won't be paying a lawyer for bringing your claim. In the fast track, and particularly because of these changes now, before you issue a claim, you're going to be thinking, well, if it does go into the fast track, my opponents, if they do choose to instruct lawyers, they may well not get their full legal costs back, and therefore they might take a commercial view and get rid of the case and settle quickly. Particularly public bodies, corporations, they think commercially about claims. They don't think about the rights and wrongs and finding things just for sake of principle. So they might make a commercial decision not to settle early. So there could be benefits to you as a litigant in person, and therefore you'll want to do what you can to persuade the court to allocate it to a track that suits you. The converse applies. I often think the best way of getting justice is by getting your case up into a higher track as possible, so you have as much airtime in front of a judge. So you can read everything and you can hear everything at trial. And often with a good, strong case, you have to go all the way to trial because your opponent, particularly if they're represented, knows that the system is such that, and there are so many little interim phases in litigation and often interim hearings, one after another, your opponent knows that they can give you the runaround, confused judges who won't have got to grips with your case. They don't read the whole blooming case before they go into court for a 30-minute hearing. So it basically ameliorates its contingency against court not being able to give ample time to hear your cases. Often the biggest problem isn't that judges favour one part or the other. It just might mean that they haven't got to grips with your case. Why it's so important to be concise and identify the issues and fight the battles that need to be fought in litigation, and not to throw the kitchen sink at it. And this is is even more true now than it was before the introduction of these new rules. So those are sort of little tactical issues because it's important to think even before issue, as I say, about what track your case is likely to be allocated to. Now there is this now big grey area. You've got the fast track, you've now got this new intermediate track, less complex multi-track, and you've got the multi-track. So the question then becomes, and this is particularly relevant, not just generally per issue, but if you haven't considered the matter at that stage, you will need to consider it when it comes to directions questionnaires, which is the stage when the court is going to allocate and listen to you when you fill in your directions questionnaire, and maybe have a hearing after those direction questionnaires have been filled in about, orders that are going to be made in respect to the litigation and what track you're going to be on, but now what complexity band you're going to be on. So this is a new change, the creation of complexity bands. There are 4 of them. I'm holding up 2 hands because there's now 4 for the fast track and the same 4 for an intermediate track. So you'll have to be telling the court in directions questionnaire not only which track it should go into, but which complexity band it should go into. And what complexity band it goes into in a particular track will impact the amount of legal costs that will be awarded, once a decision has been made in the case, at trial, let's say, or even alternative dispute resolution or mediation, or when you settle. So there you are, you've got your directions questionnaire in front of you, and you're thinking, well, actually I want this to be in the intermediate track or higher. Now, how to decide whether a case is complex or not? Well, there are 2 tables, and you'll see on these tables that in essence they're quite broad, and in essence they're saying, if it's complex, 4, if it's not complex, 1. If it's got lots of issues, it go up to a higher band. If there's argument just about quantum and a personal injury claim, that will go into a lower band. If there's an argument about law, a legal issue, it will go into a higher band. And so when you are making decisions about complexity bands, you need to have reference to these tables. Okay, no one quite knows. Don't worry, everyone's a little bit in the dark, so no one quite knows how judges will reach decisions. Because, as I say, this guidance is quite kind of vague, general, let's call it, rather than be pejorative about the people who've drafted it. So that is probably the most important sort of takeaway from this vlog, apart from the general, strategic issue of the fact that lawyers are going to not get their full costs, and they're going to pass those full costs on to their clients. Is this issue of you just needing to do follow the rules correctly and make sure you have argued your case in respect to not just which track your case should go on to, but which complexity band is relevant. As I say, to litigants in person, this is not such a big issue. To come on to more tactical benefits that might apply to litigants in person, and because it doesn't matter what complexity band your case is on, because you're not asking for your legal fees because you're running the case yourself, and you'll still be able to, and litigants in person can claim for their costs at a certain prescribed rate, which falls outside the scope of this video, but you can read about it in my book. And I don't know if I've done a vlog on it. I'll check and I'll link it in the description box below if I have. Anyway, tactical benefits arise here because, as I say, as I said earlier in the vlog, you might want to get the case into a lower track to hurt your opponent who's using expensive lawyers. Yeah, they'll make a commercial decision and settle the case because it's just too expensive for them to fight a claim on the fast track with lawyers. You might be up against another litigant in person and want to get it up into a higher track simply because you want to give the court more airtime. You want to make sure the court's scheduling it for a longer trial and proper pre-trial review, whatever other necessary stages are required in the intermediate track, or you might want to get it bounced up out of the intermediate track into the old multi-track. I don't think there are cohabitation property disputes are going to get into the intermediate track much. This is mainly about monetary claims. Cohabitation property disputes, which is the specialism of Court Wingman. I don't think that they're going to go into the immediate track, as I say, because then it's not about monetary value. It's often about other sorts of remedies that you're asking the court for. Just on this issues point, you can see how that you might want to, at an early stage, like in your defence, say, like, well, we concede that issue in the particulars of claim, and thereby, and this is enshrined in these new rules, you are reducing the complexity and potentially the value of the claim that's being brought and bringing it into a lower track, which might be of tactical advantage for the reasons that I've alluded to. Might even bring it from the fast track to the small claims track by admitting an issue, which lowers the quantum of the claim and lowers its complexity. So there's another important tactical reason. Just a couple of other things. There is a new clause that kind of rides over everything I've said to a point. It remains to be seen how it's implemented by the courts. And that is that where you can prove that your opponent has behaved unreasonably, you can make an application for an uplift that gives you 50% more, or if you're on the losing side, 50%, your opponent 50% less of those cap fixed costs for that intermediate track or fast track complexity band 1, 2, 3 or 4. Which is quite significant, 50%. And it sort of stands out, that clause, and I wonder whether or not going forward the courts aren't going to maybe apply that. They might feel they've got a worthy party who deserves their full costs, and therefore they use that clause to give it to them. I don't think it's going to happen in the majority of cases. I think a bit like with the small claims track, it's difficult to prove unreasonable conduct and get your legal costs in the small claims track because that's quite exceptional. But I think it will become more common. But I think it will become more commonplace, and the than the unreasonable conduct provisions as far as small claims are concerned. You'll want to know what the definition of unreasonable conduct is. It's where a party hasn't got a reasonable explanation for some conduct. Let's say they never did a proper response to your letter of claim. Yeah, and so we're in unnecessary litigation, or they refuse to mediate during proceedings, or some other form of ADR. So that's an area where you might want to make an application. And as I say, these new rules specifically allow, if not encourage you to do so, against an opponent whom you believe has been behaving unreasonably. So there's kind of a get out of jail free card, the jail of having your costs capped as a party, your legal costs capped as a party in that little clause. There's other stuff in there, but on the whole, it's outside the scope of this vlog. There is a change to the Part 36 offers. I've done a blog on Part 36. I don't recommend litigants in person try and draft Part 36 offers. It's too technical. But now there's a 35%, an actual figure has been put on what you get if you beat an earlier Part 36 offer that you've made in proceedings. That's the point of Part 36, to make very low offers so that you get all your costs back. Because you say to the court, I made this a low offer early on, it was ignored, I now want my full costs. So Part 36 offers will become perhaps more relevant than they have done in the past because of the introduction of this new fixed cost regime. Finally, and please, we just a plug here. With the legal surgeries are very successful and productive. They're only an hour. They're only £150, no VAT added, and we can often give quite a lot of legal advice because we spend so much time in the litigation trenches and get an instinct for what's needed in your case. If you book up a 1 hour legal surgery, and you may want to book up a 1 hour legal surgery in relation to this issue at a particular stage of your case to get some legal advice, discreet legal advice at critical points, so that it's not costing you an arm and a leg. I think that the legal landscape is changing. I think for these lower value claims, you're now going to have more court wingmans. We're going to have some competition because basically more and more people are going to run their own claims. I've always felt that it was a bit sort of top heavy with lawyers, particularly in the fast track. And I think that is the way things are going and have been going for some time. Lawyers are being priced out of the litigation game in lower value claims. Happened with personal injury, with the increase of the personal injury limit in small claims to £5,000 for road traffic offences. So that's the general direction. I think that means more and more people are going to be running their own cases and not using lawyers because it's just too expensive and too risky to end up with a large legal bill, particularly if you lose, but even if you win, getting your legal bill hacked right back, such that you in effect have to give your lawyer winnings, a percentage of your winnings, and it could be quite a substantial percentage. I read a cost lawyer's review on this who thought it could be much as clients, even if they win, the court only awards them 50% of their lawyer's costs. They've got to find the rest in their pocket. What's the point, But I've always felt, as I say, that kind of a lawyer light service was needed in the legal sector in this area, because so much of it is on the paperwork that provided you get your paperwork properly drafted, you don't need so much a lawyer to be on court record, and lawyers have to charge so much because they have responsibility and ownership of conducting litigation. They have the risks of complaints and negligent claims, high insurance premiums, having to apply all the tick boxes of being a solicitor and the solicitor's codes of practice. So better to just have them like a control tower, to use my favourite analogy of a dogfight where you're in a Spitfire, but because you're not a trained pilot, you might get beaten by an old-fashioned World War One biplane, you know. You need a control tower or a navigator to help you, but you don't really want to pay all that money to employ a pilot to go into the dogfight for you. So I think that's the direction of travel. I also think that increasingly, I just do wonder about the county court system in England and Wales. I'm just wondering whether it's fit for purpose any longer. So many delays, so many errors, it's so underfunded. Lawyers are proportionately too expensive. I don't know. Maybe the powers that be want to see the thing dismantled. It wouldn't surprise me. You know, the general drift in life now is the rich get richer. They can afford to litigate, but for there's less and less access to justice for those with lower value claims, which I think is going to see the creation of private courts. People getting together, and I actually would quite like to do this. A court wingman is to actually adjudicate two people and not have to bother with the county court system at all, and to just give us the papers, give them, you know, a couple of hours each, perhaps on the telephone, perhaps in a meeting room, and come up with a preliminary view of their case, a preliminary judgment, so that even if they don't accept our judgment, when they go to court, they'll have a much better idea of the strengths and weaknesses of their case, what it's likely to settle at, what a judge is likely to award, and so that will encourage settlement early days. And as I say, I think lawyers and barristers might in the future start offering this type of private court service because of cost. And that's already started in a way because there's a thing called early neutral evaluation, which is a form of alternative dispute resolution. It's not mediation, where basically, you know, the mediator tries and gets you to meet in the middle, which sometimes works, but, you know, if it's a boundary dispute, do I own that or don't I own that? You can't really have a judge cut that in the middle. And also, you know, in complex areas like cohabitation property disputes, you know, you don't just want someone to bang heads together. You want someone to also give you a view of what a court is likely to say about your case. So that's something I'm quite excited about, and I'd like to add as a service to the Court Wingman. So be the first. Ping us at hello@courtwingman.com and be a pioneer like we are. We'll try and settle your dispute with your opponent. So that's quite a good note to finish on. I hope that has all made sense. If it hasn't made sense, then book us up for a legal surgery. Get your paperwork together. We may have to charge you more hours depending upon the amount of paperwork and the importance on us reading the paperwork. But oftentimes we can give quite a good steer, more than quite a good, a very good steer, because we're just in the trenches, so we know the lay of the land, and we get a feel just by looking at a case what it is that you need to do. So do feel free to email us for a quote for Court Wingman service. Anything else? I don't think so. That's all for now. Probably will do a longer vlog on it in due course. I've updated the decision flow charts to help you decide whether to get legal in the first place. Subscribe and you can get those. On the whole, if you are a litigated person, don't be too worried. You only really need to go in to address it at the directions questionnaire stage, and it's probably almost certainly to your advantage if you're up against a represented party. That's all for now. Bye bye.